So throughout my presentation, there's a couple of different ways that committee members can look at this issue. There's the legal lens, which looks at this issue through the Supreme Court jurisprudence on this issue. And then there's the moral lens. And I'll talk in depth about both of those. Starting first with the Supreme Court, in 2005, in a case called Roper v. Simmons, the U.S. Supreme Court found that it was a violation of the Eighth Amendment's prohibition on cruel and unusual punishment to sentence a child to death. The underpinning of this decision really rested upon the fact that there were fundamental differences between juvenile and adult brains. This is something that the court noted that every parent knows, but the laws really hadn't caught up with at that point in time. And in particular, the court noted how the prefrontal cortex, which is the part of the brain that's responsible for emotional control, it allows us, it's sort of the executive functioning part of our brain, isn't fully developed in juveniles, the same way that it is in adults. As a result, children actually used a more primitive and a more emotive part of their brain called the amygdala to process information and make decisions. It was one of the reasons that the court noted for why the penological justifications, that is, retribution and deterrence, are diminished in light of children's diminished culpability relative to that of adult defendants. And so it was on that basis that the Supreme Court strikes down the death penalty for child offenders. 5 years later, in a case called Graham v. Florida, the U.S. Supreme Court took up a case called the court took up the issue of whether or not children can be sentenced to life without parole for non-homicide related offenses. There again, the court, relying on its kids are different doctrine that it established in the Roper v. Simmons case, found that it was in fact a violation of the Eighth Amendment's prohibition on cruel and unusual punishment to sentence a child to life without parole for a non-homicide offense. In that case, the court likened life without parole to the death penalty in many ways for a child, because no matter how much a child changes, no matter how much they're rehabilitated over time, no matter how much remorse they express, they will never have an opportunity to live in free society. The only way they will leave prison will be in a pine box. 2 years later, in a case called Miller v. Alabama, which had a companion case that originated here in the state of Arkansas, called Jackson v. Hobbs, the court took up, at the time, what we thought was mandatory life without parole sentences for juvenile offenders. And those were juveniles convicted of homicide-related offenses. There, the court said that individual judges have to have the ability to consider the mitigating factors of youth before imposing the nation's harshest possible punishments. The court went on to opine that these sentences, if they're ever imposed, should be very rare and very uncommon. In the wake of the Miller decision, there was a lot of questions as to whether or not that decision was meant to be applied retroactively. And last year, the U.S. Supreme Court, in a case called Montgomery v. Louisiana, answered that very question in the affirmative. The court went a little bit further, though, in the Montgomery decision. Not only did it say that, the court say that that Miller applied retroactively, but the court went on to say that a lot of us were actually misinterpreting and misreading what Miller actually stood for. And what the court specifically stated, and I want to read a couple of quotes to the committee because I think it's relevant for the purposes of this conversation. The court specifically said that Miller determined that sentencing a child to life without parole an unconstitutional penalty for a class of defendants because of their status. Even if a court considers a child's age before sentencing him or her to a lifetime in prison, that sentence still violates the Eighth Amendment for a child whose crime reflects unfortunate yet transient immaturity. Miller barred life without parole for all but the rarest of juvenile offenders, those whose crimes reflect permanent incorrigibility. Miller's conclusion that the sentence of life without parole is disproportionate for the vast majority of juvenile offenders raises a grave risk that many are being held in violation of the U.S. Constitution. So here in the state of Arkansas, there were about 110 cases that fit within the Miller and Montgomery framework. And to go through a resentencing for all of those cases would be vastly expensive and redundant in many ways, as the court has said that children cannot be subject, the vast majority of children cannot be subject to a life without parole sentence. What the court did, though, was it offered states a way out. They specifically stated, and I'll quote here, "Allowing those offenders to be considered for parole ensures that juveniles whose crime reflect only transient immaturity and who have since matured will not be forced to serve a disproportionate sentence in violation of the Eighth Amendment. Those prisoners who have shown an inability to reform will continue to serve life sentences. The opportunity for release will be afforded to those who demonstrate the truth of Miller's central intuition, that children who commit even the most heinous crimes are capable of change.